ACSblog is here with Melissa Hart, who is a professor of law at the University of Colorado School of Law. She testified before the Senate Judiciary Committee today on how some recent Supreme Court decisions have affected accountability of corporations. Professor Hart, can you tell us a little bit about this issue and what you testified today?
Absolutely. Thanks very much. So the hearing today was about what recent Supreme Court decisions have done to access to justice and corporate accountability. And what I was talking about was in particular two recent cases, Wal-Mart against Dukes and AT&T against Concepcion, both of which are cases that are especially notable for the 5-justice majority that exhibited enormous hostility to class action resolution of disputes in the way they framed these opinions. They're very different contexts. One is an employment discrimination class action alleging pay and promotion discrimination systemically at Walmart, and the other is a consumer class action about cell phone agreements and some misleading language and terms that they contain. So really different cases, but the common theme is that the court in both cases said, in Concepcion, they said class-wide arbitration distorts arbitration and what arbitration is supposed to do, and so we are not going to allow the California law that said that it was unconscionable not to permit class-wide arbitration with these small dollar amounts. They said federal law preempts that and really changed the balance of power between the consumer and the company, so that companies now can avoid class-wide arbitration of claims and therefore really avoid liability for these small dollar claims where it's not going to be worth it to an individual consumer to pursue the $30 that AT&T was taking from every consumer. And in Walmart, the court really redefined 23A, which is the federal rule of civil procedure that governs the starting point, the threshold issues for certifying a class. And the way they defined it, it was contrary to earlier precedent at this court and certainly all over the country. They really defined the standard for employment discrimination classes for just meeting that, what's supposed to be a threshold inquiry, to be more burdensome than the substantive standards that they've previously set for these kinds of cases, and made it extremely difficult to imagine what an employment discrimination class might look like, and particularly one challenging the kinds of subjective decision-making processes that Walmart used and that many companies now use all over this country. So they've really changed the ability of employees to pursue their claims and to hold companies accountable for discrimination.
Thanks, Professor Hart. Do you think these cases are part of a trend over the past few terms of the Supreme Court, either increasingly deciding with corporations or deciding cases that disfavor individuals?
I think they are part of a trend. I think it's much more complicated than putting it down to the corporation versus the individual, and I think we should be careful not to too easily characterize it that way. What I think they are part of a trend of is the Supreme Court really heightening the procedural requirements for getting into court so that it becomes harder and harder for a person to even have their case heard by a judge. All of these cases weren't about the merits of whether there was discrimination at Walmart, whether it was fraud for AT&T to have the clause in its contract that it did. These were just about how the claims could be pursued and whether they could be pursued. And I think that this court is showing itself as extremely hostile to various forms of litigation, particularly class litigation, but more generally to litigation period, and is imposing rules on its own as a policy matter that really change the ability of people to get access to the courts. And that will have consequences across many kinds of litigation, not just in these particular contexts.
Thank you, Professor Hart.
Thank you very much.